your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make your whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and hearts so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome to the show. I am your gracious host, Daniel, and today is Judge George Mertz. To all the new subscribers to this channel, welcome. Thank you for your support, and that goes to all subscribers to this channel. Without your support, I couldn't do this. And if you like this content and you're not a subscriber to this channel, please do me a big, huge favor and subscribe to this channel, and help let this channel grow. Say that 10 times fast. So let's get started with Judge Mertz. Make this bigger. And yes, I will be here, but I will be watching in the distance. So I'm going to mute my mic and we're going to get started.
The police, and he wanted to help that person, wanted to harbor that person, wanted to conceal that person from the police. I don't think from a factual standpoint that's a huge leap. And so interpreting the statute the way that I have, again, from a legal standpoint, I find that the knowingly or willfully applies to the concealing or harboring aspect. And from a factual standpoint, I think there's clearly a sufficient factual basis for the question to go to a jury. And those are good arguments for a jury. Those are all questions that I think a jury ultimately needs to decide. But again, from the standpoint of probable cause, there's clearly enough evidence reviewing it under an abuse of discretion standard to find that there is probable cause for that to go to the jury. So the court will dismiss I'm sorry, we'll deny the motion to dismiss. And Mr. Ziegler, I'll just ask you to prepare an order reflecting that ruling by the court.
Yes, Your Honor.
In terms of going forward with the case, Mr. Seeger, I'm not sure where you're at with your client. I mean, I'm sure you wanted to find out what
Yes,
the
Your
ruling
Honor.
would be. but-
Your Honor, if you would give us an additional 30 days, either we will come back and we will accept a plea, or in the alternative, we will just ask the court to trial or docket it for trial.
Mr. Ziegler, any objection to that?
No, Your Honor.
Okay, so we'll set this for a plea cutoff in about 30 days. So Mr. Lancer, what that means is between now and then, you need to discuss any plea offers with Mr. Seeger. At our next hearing, we'll need you to have made a decision as to whether you want to accept a plea offer in this case or proceed to trial, okay?
Yes, Your Honor.
Are you at a treatment facility right now?
Yeah, I'm at TriCap in Saginaw, Michigan. It's
Are you
correction
still
facility.
going?
Sorry.
Sure, will you still be there at the beginning of July?
Yeah, my expected release date was actually July 31st.
Okay, so Mr. Ziegler, any objection to Mr. Lancer appearing by Zoom for that next hearing?
No, Your Honor.
Okay, so Mr. Lancer, the court will approve your appearance at that next hearing in July by Zoom as we're doing today. So you'll need to sign in for that just like you did today, okay?
Yes, Your Honor.
Mr. Seeger, anything further on this file?
So, Your Honor.
Mr. Ziegler.
No, Your Honor.
Mr. Lancer, did you have any questions about how we're going to proceed with your case?
No, I'll just contact Mr. Seeger. Thank you.
Okay, thank you. You're free to disconnect at this time.
Okay, thanks again, Your Honor.
We have Mr. Hauser connecting from Ionia County. I believe that's Mr. Hauser.
Yes, Your Honor. Your Honor, because he's been in Ionia County, it's been a little bit difficult to speak with him. I did speak to him prior to him going to Ionia County, and well, we had discussed quite a few things, but in any event, Your Honor, I was hopeful that I might be able to talk to him briefly by Zoom, breakout room, just to determine what he wishes to do.
Yes, for sure. If you want to sign in, then Mr. Hauser, are you able to hear me?
Yes, I can hear you.
Okay, so Mr. Seeger, your attorney is going to connect in here. I'm going to put you and him into a breakout room so that you can have a private conversation, okay?
Okay, thank you. How you doing, Tom?
Hey, good, Mr. Hauser. So, Mr. Hauser, I canceled your
Hold on
bond.
Mr. Seeger, hold on 1 second. You're not quite in that breakout room yet. Mr. Hauser, you may need to click something on your end to go into that breakout room.
Yeah, they're doing it right now.
Okay. Okay, we'll just take a short recess until that you're going to plead guilty to 1 count of uttering or publishing. That's a felony that carries with it a maximum possible penalty of up to 5 years and or a $2,500 fine. You understand that?
Yes, I do.
And you're also going to plead guilty to 1 count of fleeing or looting in the 3rd degree. That is also a felony that carries with it a maximum penalty of up to 5 years and or a $5,000 fine. Do you understand that?
Yes, I do.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty.
Right now you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. Your only appeal of this plea would be by leave, which means you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty to each of these charges because you are actually guilty?
Yes, sir.
All right, these incidents happened on January 16th of 2025, is that correct?
Yes.
All right, and on that date, were you present here in Kalkaska County?
Yes, I was.
All right, and while you were here in Kalkaska County, did you attempt to use some counterfeit money to pay for some goods or services?
Yes, I did.
Did you know that the money that you were trying to use was fake or counterfeit?
Yes, Your Honor.
Okay. And during the course of that, did you come into contact with a law enforcement officer from Kalkaska County?
Yes, I did.
And was that officer attempting to get you to stop your vehicle or pull your vehicle over?
Yes, he was.
Did the officer use lights or sirens or something else to indicate to you that that's what they wanted you to do?
Yes.
And did you fail to do that?
Yes, Your Honor, I did.
And did you in fact drive your car in a way as to try and get away from that officer?
Yes, I did.
All right, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Likewise, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Mr. Hauser, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. The court will set this for a sentencing hearing. Do you know how long Mr. Hauser is going to be there in Ionia, Mr. Seeger?
Yeah, Your Honor, it sounded like when I was speaking to him that he has another pending matter there. His attorney is working on whether or not the matter is going to proceed to trial, or there may be some dispositive motions. He's not able to make his bond either way, Your Honor, so I assume he's going to be there for a period of time.
Has his bond in this case ever been posted?
It was, Your Honor, there should be an order in the file, and I think it was in around May 5th or so that the court had canceled his bond.
Okay, so he would be brought here even if he was released in Ionia.
That would be my presumption, Your Honor.
Okay, so Mr. Hauser, we'll have a writ prepared for you to be transferred here for the purposes of sentencing to Kalkaska County. And you'll have an opportunity to speak with Mr. Seeger about a pre-sentence report that will also be prepared, okay?
All right.
Mr. Seeger, anything further on the file today?
No, Your Honor.
Mr. Ziegler? All right, thank you. That's all for today. Mr. Hauser, the court's going to disconnect at this time.
Do we know when we'll be back in court for sentencing?
It'll be in about a month, right at the beginning of July.
Okay, thank you.
Yep, okay. People versus Kylie Wheeler.
Your Honor, Thomas Seeger appearing as the arraignment.
Goodrich present?
Yes.
Okay. The court will call People versus Jeffrey Goodrich. File number 255023. The record should reflect Mr. Goodrich present here in the courtroom today. Also, put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with on behalf of Mr. Goodrich.
All right. This is set as a plea cutoff today. Mr. Seeger, have you had a chance to talk to Mr. Goodrich?
I have, Your Honor. Your Honor, at this time, we've not come to a resolution. Mr. Goodrich is still trying to work out a potential resolution in Antrim County, which is somewhat attached to the tenant file here. And so in as much as I understand that this is a final settlement conference, Your Honor, I would ask the court to give us one final settlement conference. I have no objection to setting it for trial, as it may likely go that way, but he's still trying to resolve his Antrim file. If his Antrim file is resolved, it's likely that this one will likewise resolve itself.
Okay. So I do want to go ahead and get this set for trial, and then we'll set it for a final status conference. Mr. Ziegler, how much time do the people need to be ready for a trial in this case?
Your Honor, we could be ready at any time.
And how many days of trial do you think we would need?
So 1 day trial, Your Honor.
Mr. Seeger.
Your Honor, just a reasonable period of time, whatever that means to the court. And I would likewise agree that it would be a 1 day trial.
Okay, so the court will just conduct its usual scheduling, 1 day jury trial at the next available date, which is likely to be, at least 60 to 90 days out. The court will set it for a final status conference on the motion day prior to that date of the trial. The court will send out notices for both the date and times of both of those, the trial and the final status conference. So Mr. Goodrich, you have one more appearance before the court prior to your trial in this case. That will be the final day to enter into any pleas, okay? And you can expect that, like I said, within the next 60 to 90 days.
All right.
In the meantime, just make sure that you stay in touch with Mr. Seeger so that you're prepared to go forward. Mr. Seeger, anything else I can address for your side on this case?
No, Your Honor.
Mr. Ziegler?
No, Your Honor.
Okay. Do you have any questions, Mr. Goodrich?
No.
Okay, thank you. That's all. Thank you. Okay, there at Wexford County, I just need you to unmute.
This is Mr. Goodman, Your Honor.
Okay.
Now, you hear me?
I can, yes. Can you just tell me your name, please?
Byron Goodman.
Okay. Have you been appointed to this case, Mr. Seeger?
Your Honor, it wasn't entirely clear to me, but I can handle it because Mr. Goodman is previously my client, or not, well, previously he's been my client, but also currently he is my client.
Okay. All right, so we'll go on the record. This is file number 2514722. This is Terry Harper versus Byron Goodman. The record should reflect Mr. Goodman's appearing today by video from Wexford County Jail. Last week, on May 27th, the court entered an order revoking Mr. Goodman's bond. It's my understanding that this is a PPO matter, that Mr. Goodman was arrested for allegedly violating the PPO. He was arraigned on that, was given a bond, was released, and then allegedly violated the PPO again, or violated his bond, I'm sorry, at least, for being arrested for operating while intoxicated, with the protected individual, the petitioner, in the vehicle with him at the time. So I guess what would be a basis for 2 violations of bond. The court issued an order revoking that bond and ordering that he be remanded to jail. And again, that occurred last week on May 27th. The court then set this for a hearing today to determine a new bond for Mr. Goodman. Mr. Ziegler, are the people involved? The people are involved in this based on the arrest, I would guess.
Based on the alleged OWI and the other attendant charges, yes, Your Honor, but we don't hear on a PPO matter unless the court directs.
Okay. Mr. Goodman, did you want to have a chance? We have Mr. Seeger here to assist you as a court-appointed attorney. Did you want to have a chance to speak with him before we go forward?
No, I just want to ask you a question. Can I ask you a question?
Okay. Yes.
Ms. Harper put in for a PPO termination, and I'm wondering why they ain't terminated yet. And I got a PR bond. Yes, I messed up and violated the bond, which I understand is wrong. But she shows no fear of me, just keeps calling me and talking to me. I talk to her. We hang out together. That's why we both got arrested on the 27th or 25th for hanging out.
So, yeah. Mr. Goodman, I don't want you to talk about anything that you say here during this hearing could be used against you. So I don't want you to make any statements that could incriminate you. I think I can answer your question, though. I think, first of all, Ms. Harper has to file a motion to have the PPO terminated. The court has to have a hearing and then issue an order before it's terminated, and that takes some time. It just doesn't happen automatically when she decides she doesn't want it anymore. That's not how it works. So let me just explain to you. Let me, Mr. Goodman, let me finish explaining to you, and then we'll see if you still have questions, okay? So the PPO is still in place, and it will be until that motion's filed and the court can hear it and sign an order to terminate it.
Yes, sir.
The PPO prevents you from having contact with her. And so that means that regardless of whether she tries to contact you, you have to say, I can't talk to you, I can't be around you, stay away from me. You know, you can't have contact with her. And I understand that that's difficult when the person who asked for the PPO is trying to contact you. That doesn't make a lot of sense, and I get that. But you cannot be around her until that order is terminated, all right?
Yes, sir.
So if she tries to contact you, you've got to get away, say, no, I'm not talking to you, I'm not going to be around you, and you need to remove yourself from that situation because you're the one who's going to get in trouble as you're finding out.
Yes, sir. Yes, sir.
In terms of a new bond here, Mr. Ziegler, are you aware of what the bond is on the OWI case?
I don't recall off the top of my head, Your Honor. I want to say it was in the area of 20,000, 10%.
Okay.
What?
So Mr. Goodman, I'm going to reinstate your PR bond on this PPO case. I think you spent a few days in jail now on this. I've had a chance to explain it to you. I think chances are that you've learned your lesson here and you understand that you can't have contact with Miss Harper. So I'm not going to impose an additional money bond over what you're already going to be required to post in that separate case. So the court is going to reinstate your bond on the PPO, and I'll issue an order today to that effect. So to the extent you're being held in jail, it won't be on this PPO matter, okay?
Yes, sir. I got one question though. Could you
Sure.
change my address, take her address of mine, and put it towards Mansalona, because she's not on my address no more. I get in trouble for that too, but Ziegler knows that Mr. Officer Creighton contacted him saying that on the sex registry she was homeless and then she went from homeless to her new address. She no longer lives at my address. So can you clear that up too today? Saying, take her name off my address so I can go back to my house without having to worry about cops showing up at my door?
I have no idea. I can't change anything about her address. I can only change your address if you have a different one.
I live at my house. They said I could live at my house. Even Ziegler did because Officer Creighton called him because Terry's in the sex registry. He left my house. He ain't been there for over a month or a month and a half. Since he did this bill. She lives in Mansalona now. So
Mr. Seeger, do you know if Mr. Goodman's been appointed an attorney in that other case, the OWI case?
Yes, Your Honor. Currently I am his attorney.
You are, okay. Can you advise him on that home issue?
Relative to what, Your Honor?
I can't give him advice about whether he should go back to the house or not.
well, I did go back to the house. Ziegler says I could. And Officer Creighton did.
All right, so Mr. Goodman, I don't know if I'm prepared to discuss that with you. Let me try and set up a Zoom meeting with you or come to the jail manually so that we can discuss.
And ain't no big deal. I've been going to the house, so I'm just wanting you to take it off the address while we're in court. But if you can't do it, I'm all right because I've been going to the house there and I had no problem. I'm just saying that I make switch the address.
Oh, okay, so let's just talk about it later, Mr. Goodman.
All right. Thank you.
Okay.
Okay. All right. Thank you. That's all for today, Mr. Goodman.
All right. Thank you, sir.
Do we have Mr. Barkovich? Yes, sir. Okay. Mr. Barkovich, if you can go to the podium there, please. We'll go on the record and People versus Terry Jordan Barkovich. We've got a number of files for hearing today, 25-5009, 5010, 5011, 5012, 5015. This is the date and time set for sentencing in this matter. The record should reflect that Mr. Barkovich is present here in the courtroom. And if I could have counsel for your appearance.
Brian Ziegler, Your Honor.
Thomas Seeger agreeing with an update of Mr. Barkovich.
Thank you. This is the date and time set for sentencing in this matter. Mr. Barkovich, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes, sir.
Oh. Mr. Seeger, just so that you're aware, I did receive a letter from Mr. Barkovich that I had a chance to review prior to the hearing today. Are there any additions, deletions, or corrections?
They're not here.
Are there any challenges to the scoring
They're not here.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your
Do the people have any challenges to the scoring?
Honor. No, Your Honor.
Are there any victims that wish to address the court today?
I don't believe so, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, there's obviously a lot to say about the defendant and his string of offenses in this case. Fortunately, the PSI does a very good job of laying out each one of these cases individually and what happened. And the court has had the benefit of reviewing the reports for the no contest plea. As such, I'm just going to hit the highlights here. The defendant has 9 contemporaneous open files in this county. I believe that is a record, at least during my tenure. He's pending sentencing on 6 felonies here and 2 more in Antrim County. The defendant has a lengthy record and was on parole at the time. The crimes the defendant was accused of and pled guilty to were largely victim crimes, larcenies, and burglary type offenses. And one offense that was not along those lines was an attempted escape from the jail here in Kalkaska, which was on video. And the video shows him getting a significant portion of his body through the booking window, through the bars there, right in the booking window at the jail. And but for the corrections officer turning around and seeing him trying to get through the bars, it appears likely to me he would have succeeded, gotten into the control room of the jail, and then fled the facility. The defendant's record on parole, as indicated in the PSI, is poor. It includes multiple positive drug screens, multiple issues with absconding. His history on probation is poor, multiple failures on probation and other files. His course of conduct in this case involved a protracted manhunt and a string of larceny offenses, including 4 UDAAs and a home invasion to which he pled no contest. There is simply nothing to redeem the defendant, Your Honor. The guidelines are wholly inadequate to address his conduct. He's already 20 points over the maximum PRV score for his grid, and that's only scoring 2 subsequent convictions when he has 8 concurrent convictions across both this county and Antrim County. Even setting Antrim aside, because he will be sentenced in Antrim, the defendant has 6 concurrent felonies here in Kalkaska, 5 of which were entered as a habitual second. There's simply nothing to do with the defendant, Your Honor, other than to return him to prison for as long as possible to prevent the community from being further victimized. I would recommend simply Tanner ruling him on every single one of these files, Your Honor, giving him 60 to 90 months on everything but the escape, and then 32 to 48 on the escape, which runs mandatory consecutive. Barring that, I would ask the court to give him the top end of the guidelines on each offense. Thank you.
Thank you. Mr. Seeger?
Yeah, by way of elocution, PJ has had a triple past and he's made a lot of mistakes and he recognizes that. And unfortunately for Mr. Barkovich, he's struggled with a drug addiction for an appreciable period of time, and he has used that as a coping skill for himself, as much as that has been self-destructive behavior, which he recognized. Prior to being released from prison, he had been dealing with the passing of his mother. I think that he was struggling with that significantly. And then when he was released, he didn't have the coping mechanisms to deal with that. Wasn't able to go to a funeral. He wasn't able to, say his goodbyes. There were a lot of things that happened. Be that as it may, Your Honor, Mr. Barkovich is remorseful for his actions. He recognizes what he did was wrongful. He accepts responsibility for it. But to his credit, in as much as I don't disagree that there's quite a few different charges, he's not a violent person per se. So he's not out, hurting people in the same way that it's somewhat characterized as being. I agree you shouldn't take other people's property because clearly that's illegal, clearly that's wrongful, clearly that's hurtful to someone else. But he's not an assaultive type person. Moreover, Your Honor, in as much as he was on parole, which is a detriment to him, those sentences run consecutive. So he lost a bunch of time for which, when he was unable to resolve his files, all that is dead time. He doesn't get any credit for it. Fair enough. He probably shouldn't get credit for it, but we just ask the court to take that into consideration. Mr. Barkovich is hopeful that, now that he's had a little bit of time to address some of the grieving process that he needed to address, that hopefully he'll be able to maintain his sobriety. Hopefully when he's released from his incarceration, he'll be able to find meaningful work. He did indicate to me that at one point in time, he did have some meaningful employment lined up, and then for whatever reason, it just all fell apart. And I think with many people, what happens is one thing happens, and then another thing happens, and then at some point, you just give up hope. And I think to a larger degree, that's what happened to Mr. Barkovich. In terms of the ultimate sentence, Your Honor, I would just ask the court to fashion a sentence within the guidelines. He is understanding that he's likely to be returned to prison. The question becomes what the court does with the consecutive portion, which is the attempted escape. In my view of the video, it is clear to me that he attempted to escape from the jail cell. He was in the booking window. He stuck his head through it. He maybe got one shoulder through it, but it wasn't entirely clear to me that he could have actually gotten through the entire bars, even if he wanted to. He may have been able to partially get through there, but I don't know as if he was going to be able to actually get through the bars. Be that as it may, Your Honor, he recognizes that his conduct was wrongful. He's asking for the court to give him something at the lower end of the guidelines with the understanding that that's going to run consecutive to the other issues. Additionally, Your Honor, I'm not sure what's going to happen in Antrim County. However, I did speak with his attorney, and his attorney had indicated that he thought that there may be a meaningful sentence that's handed out there that's not necessarily for the court to consider here. But when fashioning a sentence, I'm just trying to make it proportionate to what he did, which essentially he was on a drug-induced stealing of cars and other things that he shouldn't have done, primarily because he just wasn't thinking clearly. And that leads me back to the jail escape. He was coming off a high, and so he wasn't thinking clearly then either. In any event, Your Honor, he recognizes what he did was wrongful. He recognizes that there's a consequence. He's just asking the court to give him a sentence within the guidelines. And then in terms of the consecutive portion, Your Honor, he's asking the court to consider giving him 12 months, which is still a very meaningful thing. I would note that Officer Duran was not struck in any way. It's not a situation where he was like, you know, tussling with a guard or another person to get out of the jail. He appeared to just try in a moment of opportunity to slip his way through the bars, which he was unable to do. The whole instance lasted maybe like 3 seconds. So if it was an attempt, which clearly it was, because that's what we pled to, it was not a meaningful, long, protracted event.
All right, thank you. Mr. Barkovich, was there anything that you wanted to say to that?
First, obviously, I'd like to apologize to the people that I victimized, and I know I affected their lives in some form or fashion. Apologize to the police force and the community for wasting their time and resources on my stupid actions. I don't disagree with the prosecutor in many regards. I look at myself a lot the same way, and that's a lot of my issues is I don't necessarily love myself or care enough about myself. Things that I've been through have brought a trauma, a different way of thinking that I use drugs to cope with. Not saying that that's the perfect solution at all. I know I got to find a way to forgive myself and find a way to love myself again. I know I need help. I want help. The person that stands here today is not the person that did these things. It's not a person who's happy with the things that were done. But unfortunately, there's another side of me that isn't a good person. And I want help. I know I need help. I don't want to continue being like this. I understand that I deserve prison time. Only thing I do try to ask is if maybe on the consecutive charge, somehow I could get like a year in a county jail where I can be afforded opportunities like teen challenge or rehabs or things that will actually help me in the long run. So I can be the person like I have good trade skills, getting jobs and employment. I went from making $50 an hour to this. Like, I can be a productive member of society if I can get rid of the other side of me and learn how to deal with my addiction. I did some outpatient things. I've never been to like a rehab or a place where I have an extensive plan put in place to help me. Like, yeah, prison's prison, like being around a bunch of negative influences, drugs, corruption, that's a hard place to change in. I'm not saying that what I did doesn't deserve that, but I also, at some point in time throughout this, would like to get the help I need. That's all.
I did read through the report, going through all these circumstances, this kind of string of crimes that you engaged in November of last year here in Kalkaska. There's obviously a lot of information in that report about you personally, your background, history, and so forth. I take all of that into account. Like I said, I also read your statement very carefully. Take that into account along with what the attorneys have had to say. And, you know, I thought your statement was interesting because when I see the charges, when we took the plea, when I read the PSI, it's like, what is this person? Is this just somebody who's just a criminal, or are they going through something that's causing this kind of behavior? You know, are they just a bad person? Or, you know, in your case, I don't think that's the case based on what I read and just based on your history. I thought your statement was pretty sincere in terms of admitting where your fault is here. And I think you're probably not a bad person deep down, but you do have issues when you're under the influence of substances, and you do a lot of bad things and you victimize other people. And the problem with that is that the people that are victimized, it doesn't matter to them what your reasons are. They see the outcome of that and they see the effect on their lives that it has. And I say that because I think, you know, there is the potential for rehabilitation if you're going to put in the work to do that. Because I don't think you're just, you know, a criminal at heart who's just going to victimize people because you have this drive to just victimize people. I think you do bad things when you're under the influence and you're not in your right mind. And I, again, that's not an excuse, but I think it's an explanation, and I think it goes to the potential for rehabilitation in your case. That kind of rehabilitation hasn't happened yet. And I think from the court standpoint and the community standpoint, given your record, that point is passed in terms of when the court's going to order that. That doesn't mean that you can't seek that out. Like you said, you know, once you've served your time here, seeking out resources and treatment to help yourself, because you don't want to get back on this Ferris wheel again. But at this point, that's going to be up to you to determine how you want your future to be and what actions you're going to take on your own. Because of your past history, because of the string of crimes in this case, because of the effects that it has on the victims, the court's not in a position to do that. In terms of the prosecutor's position that the court should go above the guidelines and sentence you to the actual maximum extent allowed by the law versus you through your attorney request for the court to sentence you at the lower end of the guidelines. I think the sentence in this case is going to be sufficiently punitive because of your parole status, because of the consecutive nature of the escape charge, that going above the guidelines isn't warranted, and because I do think there is some potential here eventually for you to get some help for your underlying addictions, for the underlying trauma that you're treating with those addictions. That the court should not go above the guidelines, but I also don't find, again, based on your past history, the effect on the victims here, that there's any reason to go lower than the upper end of the guidelines on all the charges. So for those reasons, the court finds the following sentence is reasonable and proportionate. As to file number 5009 is unlawful driving away. The court sentences you to 36 months to 7.5 years in the Michigan Department of Corrections with credit for 0 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to file number 5010, the UDAA charge, court sentences you to 47 months to 7.5 years in the Michigan Department of Corrections. A crime victim's assessment of $130 and the state cost of $68. As to file number 5011, I'm sorry, I'm gonna discuss that one last. As to file 5012, unlawful driving away. Court sentences you to 47 months to 7.5 years in the Michigan Department of Corrections. Credit for 0 days served. Crime victim's assessment of $130 and a $68 state cost. As to file number 5015, on the charge of UDAA, 36 months to 7.5 years in the Michigan Department of Corrections with credit for 0 days served. As to count 2, the home invasion, 36 months to 7.5 years with 0 days served credit. On that file, $130 crime victim's assessment and $136 state cost. All of those files to be served concurrent to each other, but consecutive to any penalty for parole violation. As to file number 5011, which is the escape charge, the court sentences you to 24 months to 4 years with credit for 0 days served. A crime victim's assessment of $130 and a $68 state cost. That sentence to be served consecutive to your parole violation and consecutive to the sentences in files number 5009, 5010, 5012, and 5015. You do have the ability to seek an appeal of each of these sentences. We're going to provide you with some paperwork that explains to you what your appellate rights are. Mr. Seeger,
For the record, returning a copy of his appellate rights to the court, giving him a copy of his own.
All right, thank you. Mr. Darkovich, you are remanded to the custody of the state at this time. All right, sir, can you tell me your name there at Wexford County?
Derek Williams.
Travis, are you ready on this one?
We are, Your Honor.
Protocol People versus Derek Williams, file number 255043. The record should reflect that Mr. Williams is present today by video from Wexford County Jail. recording sheet here. Okay, we're back on the record. Again, People versus Derek Williams. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of People, Your Honor.
Kyle Travis on behalf of Mr. Williams, Your Honor.
Thank you. Mr. Travis, can you tell me the status of this file, please?
Yes, Your Honor. We waived the preliminary exam in this matter based on an offer of a use of methamphetamine. The underlying charge is possession of methamphetamine. Mr. Williams would like to avail himself of that offer and enter a guilty plea to the misdemeanor charge of use.
And is that's a 1-year misdemeanor?
It is.
Okay. Mr. Williams, were you able to hear that?
Yes, yes, sir.
Have you had adequate opportunity to speak to your attorney about that plea agreement?
Yes, sir.
And is that how you want to proceed today?
Yes, sir.
Okay, Mr. Williams, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes,
Thank you. You can lower your hand. Mr. Williams, are you currently on any kind of probation or parole?
no, sir.
All right, and you understand that the maximum possible penalty that you could face for the charge of use of methamphetamine is up to 1 year in jail?
Yes, sir.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify yourself if you wanted. Do you understand all those rights?
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we've said here in court today?
no.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty because you are actually guilty?
Yes, it was on me. Yes,
All right, so counsel, is this date correct? The date on the information is 2020?
It is.
Yes, Your Honor.
All right, so this occurred some time ago, Mr. Williams, back in 2020. Do you remember that incident back on September 5th of 2020?
yes. I kept calling Calcasta, letting them know that I would be there to take care of that matter.
Okay.
Yeah.
Do you remember being here in Kalkaska back on September 5th of 2020?
Yes, I was picking up my girlfriend to bring her back to
Okay.
Oklahoma.
All right, and the time, at that time, when you were here in Kalkaska County, did you have some methamphetamine?
It was in my coat pocket. I had the glass stem in my coat pocket.
Okay,
It was a pipe, Your Honor.
all right, and did that have some methamphetamine residue on it?
Yeah, inside of it, yes, it did.
And did you have any right to have any amount of methamphetamine at that time?
No.
Okay, Mr. Ziegler, are the people satisfied with the factual basis?
Yes, sir.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people satisfied, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Williams, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. Mr. Travis, how did you want to proceed with sentencing in this matter?
Your Honor, I've spoken with the prosecution, probation, and Mr. Williams, and we were going to ask the court to proceed directly to sentencing.
All right, Mr. Williams, do you have any objection to having the sentencing hearing right now?
Right, go ahead. No, I don't have any problem.
Okay. Mr. Ziegler, anything you wanted to say regarding sentencing in this case?
Your Honor, as the court has already noted, this is a relatively old case. I think the warrant was issued in 21, and it just, I don't believe he was in the state of Michigan, or if he was not here frequently. So it just took some time to track him down. The plea was to a use of methamphetamine. I believe Mr. Williams has remained in custody since his arraignment in March 19th. So he would have around 74 days credit already. Given that, Your Honor, and given that it's a misdemeanor, I would just ask the court to sentence Mr. Williams to time served with any fines and costs that are statutorily required.
Thank you, Mr. Travis.
Yes, Your Honor, we would similarly ask the same. I would know Mr. Williams is, his wife resided here back then. He was up to pick her up. He resides in Oklahoma, has for the majority of his life. He came and turned himself in to take care of this case. One of the things that kind of brought this to light is he was explaining to Your Honor, contacted the court, attempted to plea by mail, didn't really understand just the differences between here and Oklahoma. But it came to a head because he and his wife were planning to move to Florida, and he was talking with folks about getting a job in Florida, and this came up. And so he came back to Michigan to deal with it. So I think that shows a reasonableness we don't often see. And I would just note that it's his intention to hopefully move to Florida and get a job, but if not, he would return to Oklahoma, where he's generally resided his entire life. Thank you, Your Honor. And he also has a very, very limited criminal history, no felonies or anything of that nature.
All right, thank you. Mr. Williams, anything that you wanted to say today?
No, I just gotta, I come to take care of me and my wife's business. Like I said, I'm 60 years old. I just retired from the United States Postal Service. Also, I was hired from Homeland Security, and I'm planning on either getting back to Homeland Security when I get to Florida. And when I got stopped for this particular deal, the officer, he let me go, and I'm like, man, that's a miracle. And I'm like, I'm telling my wife, see, you got to do the right thing, because her father told me to come and get her. She was with the wrong crowd, and we broke up in Oklahoma, and she came back to Michigan. I don't know Michigan, and so I'm just lost here in Michigan. But I was letting my wife know that when you do the right thing, being a productive citizen of the United States or any state you're in, it pays off at the end when you just do the right thing. And so my wife, she's been clean and sober 5 years. 2020 when I got it and brought her back here and to Oklahoma. Well, I'm not in Oklahoma, but brought her back to Oklahoma. So she's 5 years, and she's doing well. She's got mental, like bipolar or something she's got. Grand Lake Wellness, we're trying to figure it out. But other than that, we're doing great. And I knew I had to come and face my past, and this is my past. And so when I leave from here, Judge, you won't see or hear from me, not on this side of the law, maybe on the right side of the law. And basically, that's all I have to say.
All right. Okay. Thank you. So based on what you've had to say, what the lawyers have had to say about the circumstances here, I'm satisfied that this is an isolated incident that occurred, 5 years ago. I think, as has been acknowledged, I think it's admirable that you've come forward to get this taken care of in the way that you have. And so I think that warrants consideration as well. And I think that the time that you've served on this charge, waiting for this to get resolved, is more than adequate to address your wrongful conduct in this case. So the court is going to sentence you to 74 days in the Kalkaska County Jail with credit for 74 days served. The court is required to impose a state cost of $50, a crime victim's assessment of $75, court costs of $325, and an attorney fee of $350. You do have the ability to seek an appeal of this sentence. If you wanted to do that, you would need to file that appeal within 21 days of today's date. If you had other questions about that, you could, Mr. Travis would be able to explain that to you. Otherwise, you should be released. I'm not sure, what procedure are they following when somebody's released? Do they transport them here to Kalkaska and process them, or are they released directly from Wexford County?
Sir,
They can request to be released in Wexford, they're brought here.
Okay, so that process will start today, Mr. Williams, to get you released, okay?
okay, is it any way that they can transport me to, my wife got all our personal business, my bill folder, my lawyer know, he know, I was trying to get there where my bill folder and my driver's license and all my personal items is criteria is there.
So the situation is, Your Honor, his wife had a warrant out of Petoskey. So when he basically turned himself in, he gave her all his belongings, but she was then picked up on a warrant from Petoskey. So we believe actually his wife's going to be getting out today from Petoskey, but all his identification is up in Petoskey most likely. But it would be closer to be released here than Wexford if he's trying to get to Petoskey.
Yeah, so we'll have you processed here in Kalkaska, Mr. Williams, and then from there, I don't have any control over what
Okay,
happens after, okay?
okay, I'll talk to Sergeant Tiller. Tiller's good.
Yeah, okay.
Tiller.
All right, thank you. That's all for today. The court's going to disconnect at this time.
Thank you, Your Honor.
Can I get the PAT code for that?
I will get it to you.
Oh.
I got it right down.
Do you have Mr. Chapman, Mr. Travis?
Mr. Chapman is here in the courtroom, yes, Your Honor.
So we'll go on the record as People versus Wyatt Chapman, file number 244957. The record should reflect Mr. Chapman's present here in the courtroom today. If I could have counsel to put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Chapman.
This is set for a status conference. I know that a criminal responsibility report was requested. That's been received. I did have a chance to review that. I'm sure counsel has as well. So in terms of proceeding with the case, Mr. Travis, have you been able to talk to Mr. Chapman about how he wants to proceed?
Yes, Your Honor. And I've spoken with Mr. Ziegler. We did, I believe, get an offer when we waived the prelim to a joyriding or the 2-year version of unlawful use, and Mr. Chapman would like to accept that plea offer.
Okay, so the maximum penalty is 2 years?
Correct, Your Honor.
Okay, Mr. Ziegler?
That's correct, Your Honor.
Mr. Chapman, have you had an opportunity to talk to Mr. Travis about this agreement?
Yes, Your Honor.
Is that how you want to proceed as well?
Yes, Your Honor.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Mr. Chapman, are you currently on any kind of probation or parole?
No, Your Honor.
And you understand that the maximum possible penalty for this charge of, what did you say it was? Joy?
It's called unlawful use of an automobile, Your Honor.
Okay.
Sometimes referred to as joyride.
Okay, unlawful use, that the maximum penalty for that is up to 2 years in jail or prison. Do you understand that?
Yes.
With that in mind, what is your plea to that charge today?
Yes.
Right now, you have certain rights. I'm going to go through those with you. Did you have a question?
It just feels like I should be pleading not guilty, but
Yeah. I guess I have to plead guilty, sorry.
Do you want a chance to talk to Mr. Travis?
Yes, please.
Okay.
Yes, I would like to plead guilty, Your Honor.
Okay, so you are pleading guilty, is that correct?
Yes.
All right. So right now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are guilty of this charge?
Yes.
The information I have indicates this happened back on August 1st of 2024. Is that the correct date?
I believe it was July 31st, Your Honor.
Okay,
Maybe it was August 1st though, but I just know it was at the very end of July.
okay. And at that time you were here in Kalkaska, is that correct?
Yes.
And did you take possession of someone else's vehicle while you were here in Kalkaska?
I did.
And did you drive that vehicle?
Yes.
And did you have permission from that individual to use or drive that vehicle?
No.
Okay. Mr. Ziegler, are the people satisfied with the factual basis?
I'm satisfied.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
And the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to check in with Agent Barrett from the probation department for a pre-sentence report. Make sure you stay in touch with your attorney, Mr. Travis, okay?
Yes, sir.
All right. Thank you. That's all for today.
Thank you.
People versus Nathan Canfield, case number 244979. Mr. Canfield present here in court today.
Your Honor, I have had no contact with Mr. Canfield.
Okay, let me go grab it.
That's another one where we're checking on restitution.
Oh, okay, I have them up on my system here, so
Well,
let me
I don't know that we need to file, but if you can look.
Yeah.
This was set for a restitution review hearing, so the court is going to check with the clerk and see where that stands.
I don't know that any payments have been made.
Is he on probation? Did you verify, do you know, is he on probation, or I'm assuming the court set this for review because he didn't get probation? It's the only way to keep track. Okay. All right, and Mr. Travis, you indicated you've not heard from Mr. Canfield?
No, Your Honor, in reviewing his file and looking at his PSI and things, he was incarcerated the whole time I represented him. And so I never had a phone number for him, and probation did, I don't think he had a phone. And I have not since had follow-up contact, and I don't have any way to get a hold of him.
Okay.
And going through I'm sure someone could get a hold of him, but I didn't have an address or a phone number to reach out to him at.
All right. So in light of Mr. Canfield's failure to appear today, along with the court record, which indicates that he has not paid any of the restitution, and considering that the purpose of this hearing was to review payments towards restitution at the time of sentencing back in January, the court will request that the people issue a bench warrant for Mr. Canfield's arrest. We'll proceed further once Mr. Canfield's brought before the court.
Yes, sir.
Do you have Mr. Hun?
He would be, I believe, on Zoom. He's incarcerated.
Not connected yet. Are you ready on Ms. Weaver's case?
Yes, sir.
Okay, so we'll go on the record in People versus Ann Weaver, file number 24498. The record should reflect that Ms. Weaver is present here in the courtroom today. If I could have counsel with your appearances.
Ryan Ziegler on behalf of people, Your Honor.
Kyle Travis on behalf of Mrs. Weaver.
Thank you. Ms. Weaver, this is the date and time set for sentencing, and you had a chance to go through the pre-sentence report and talk to Mr. Travis about that.
Yes.
Mr. Travis, are there any additions, deletions, or corrections to that?
Well, yes, one substantial update that the restitution has been paid.
Mr. Ziegler?
I can confirm that, Your Honor. We're in receipt of a check for $54,000 from Ms. Weaver to the victim. We're still working on dispersing that, but it's been paid.
Okay. Any other additions, deletions, or corrections?
Not that I'm aware of, Your Honor.
Any challenges to, I'm sorry, this is one of the misdemeanors, so there are no guidelines. Mr. Ziegler, any additions, deletions, or corrections?
No, Your Honor.
And do you have any victims that wish to address the court today?
So,
Anything on behalf of the people for allocution?
Your Honor, this has been somewhat of a long road, but at the start of this, the primary concern in my mind and in general in these kinds of cases is making sure the restitution gets paid. And in this case, the amount of restitution was obviously substantial. It was over $50,000. I had made this offer with every expectation that that restitution would probably never be paid, and we would end up with some different plea. I'm reasonably satisfied that the case is ending in this way, where the victim is going to be made whole. So I'm happy to resolve it with a misdemeanor in that sense. The only remaining question is what the penalties should be for the misdemeanor. I think, given that it's a one-year misdemeanor, Your Honor, she already has credit for 131 days. The financial penalties are going to be meaningful. I'm satisfied with what has occurred in this case to this point. I certainly understand probation and parole's recommendation for a full year in jail. I'm not going to say she's not deserving of that, given her record and given what she did in this case. But from the people's perspective, Your Honor, the primary goal of bringing these cases is to make sure the victim is made whole. And that has happened in addition to some significant amount of jail and punitive fines and costs. So I'm satisfied as a Your Honor.
All right, thank you, Mr. Travis.
Thank you, Your Honor. Your Honor, this was a large amount of money. It was Mrs. Weaver's intention, and she applied, and she knows this is not how this should have been done. She was intending to start up a business. There's actually a tow truck that's kind of a mess relative to this case that was seized as evidence of some significant value that's in impound. Ms. Weaver's probably we don't know yet what the impound yard is going to do, but there's indications that they're going to give her a hard time about getting that truck back, even though it was placed there as evidence. So a lot of these funds were intended to help Ms. Weaver start this business, and it was her intent to basically live with her aunt and mother and take care of them and exist as this family unit. They did things clearly inappropriately. That's why we're here, but it wasn't the ultimate goal to just run away with this money and do whatever she wanted. So albeit it is quite serious, the fact that the money's paid back, the fact that the difficulties financially are not over for Mrs. Weaver. She's taken out a substantial loan to pay this back and is going to have to work to get this money back. Because of this case, wise or not, or appropriate or not, the business she was trying to develop and start was completely derailed and really had no chance to get off the ground. Don't know if that would have been successful or not, but there was kind of a whole ball of things that did not work out how Mrs. Weaver envisioned. I just note that, to Your Honor, because it wasn't as though she was just running off with a large sum of her aunt's money, albeit she knows what she was doing wasn't what she should have been doing. So we would ask the court to sentence her to time served. She's done a true 5 months with good time, what would be 6 months, which is half of the penalty. And she still is going to have troubles from this going forward financially. So it will not be over for her, even if Your Honor does sentence her to time served. There's still going to be issues for her to deal with out of this. Thank you, Your Honor.
All right, thank you. Ms. Weaver, anything you wanted to say?
Basically, Mr. Trevor has said it all. It wasn't intentional to embezzle money from my aunt. I really came up here with nothing, tried to start a business, and it became a whole ball of, we did not do it the proper way. I've learned a great deal lesson with this. So yes, I would obviously prefer time served at this point, because I still have to make house payments now of a bigger amount than I was making payments back to my Aunt Gert, along with my tow truck, a $17,000 truck that has been impounded by the state of Michigan, that I really can't afford to get a lawyer, pay $5 grand to fight the state of Michigan and or 258 tire, which I have been informed that they will try to take my truck and fight me for it. I can't do that and start a business and keep my payments and just do everything properly. So it's kind of stressful at that point. I don't know if you can do anything about that, or if there's anything that can be done. But to have that truck released and at least taken back to their residence to where the truck was taken, and then I can have somebody pick it up to resell it to try to recoup some of this money.
Okay. All right, I reviewed the pre-sentence report. There's details about what happened in this case in there. There's also information about your past history, your background, your circumstances,
Absolutely,
and so forth. And so the court takes all of that into account when determining what is an appropriate sentence in this case, along with what you've had to say here today and what the lawyers have had to say. I do think, if you were somebody who didn't have any kind of past criminal history at all, I might be willing to buy that this was a completely innocent, I was just looking out for my aunt and trying to help her out. I don't believe that. I think there was a large sum of money here that you had access to. I think that was a temptation that you were unable to resist, and you thought of ways that you could spend that money to better your life. If you can make some kind of argument that that was going to collaterally benefit her too, that'd be great. But I don't think your true intention here was to help out your aunt. I think your true intention here was to help out yourself. So I don't believe that this was just a completely innocent use of the money. And so I think the fact that charges were brought is appropriate. And I also think that the jail time that you served is appropriate. I also think that, you know, to your credit, you've done a lot to try and get this paid back, and you've done that. So I think that deserves some recognition as well. In relation to your wrongful conduct. And so I think balancing those two things, I tend to agree with the prosecutor. There's been a punitive aspect to this that addresses your wrongful conduct. There's been full restitution to the victim, which was an important consideration, mitigates your wrongful conduct. And it does sound like, you know, you're still going to be cleaning up some of this mess, and you're going to suffer some additional penalties financially as a result. So because of all of that, I don't think the court needs to impose any additional jail time. The matter with the truck is not under my jurisdiction. Also, there's nothing I can do as part of your criminal case to address that. That's something that you have to seek your own remedies for. But again, I do think the resolution here is appropriate with time served. So the court is going to sentence you to the Kalkaska County Jail for 131 days. You do have credit for 131 days served. The court is not going to order restitution as part of the sentence because that's already been paid, but the court will impose the statutorily required fines and costs, which include a crime victim's assessment of $75, court costs of $325, attorney fees of $350, and a $53 state cost. You do have the ability to seek an appeal of the sentence. If you wanted to do that, you would need to file your appeal within 21 days. If you have more questions about that, Mr. Travis would be able to help you with that. Otherwise, you just need, after you're done with court today, you just need to go to the clerk's office to make arrangements for payment of those fines and costs. Mr. Ziegler, anything further for the record?
No, Your Honor.
Mr. Travis.
Nothing further. Thank you.
Good luck to you going forward. Mr.
Thank you.
Thank you. Your Honor.
Is this Mr. Hunt?
It is, Your Honor.
Can I get by?
Mr. Hunt, are you able to hear me okay?
Yes, I can, sir.
All right, we're on the record in People versus Thomas Hun. This is file number 5255028 and 5041. The record should reflect Mr. Hun is present by video today from Wexford County Jail. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Hun, Your Honor.
Thank you. Mr. Travis, how did we want to proceed in these files today?
So, Your Honor, it's my understanding that the prosecutor would offer to resolve as a global resolution if Mr. Hun pled to one count of operating while intoxicated, third offense, and then in the second file, a count of resisting and obstructing. And it's also my understanding on the resisting and obstructing, we would be asking the court to take that as a no contest plea due to intoxication and lack of memory.
All right, so with that, because we have OWIs in both files, so are you saying dismiss one file, lead to an OWI third in one, and RNO as an added count?
That's correct, Your Honor. I'm not picky as to which OWI it is, pleading to one OWI third offense in either of the files.
Okay.
And then in file 5041, an added count of resisting and obstructing instead of the police assault on a prison employee.
Okay, so I think for court records, I think it would be cleaner to just dismiss file number 5028, have them plead to count 1 in 5041, and added count 5.
I understand that, Your Honor. The reason, well, there's two reasons. One is there may be a scoring issue with him pleading in the second file. The other one is, in just looking through, I didn't have, I couldn't find the blood result from the most recent file. And Mr. Hunt had indicated that he couldn't remember that one, so that would have to be a no contest of both. And I was struggling to put together appropriate reports to hand to Your Honor to make that no contest plea to the drunk driving myself.
I do have a blood result in, I believe, both files, but at least the second file, Your Honor. So I don't know if the defendant would be able to lay a factual basis to it, but it exists.
Do you have a police report for the RNO?
I do, Your Honor.
No problem with that.
Yes, sir.
So, all right, I guess I'll leave it up to you, Mr. Travis, then, as defense counsel, what file you want, what OWI you want, Mr. Hunt, please.
So I would ask that we plead in file 5028 to the OWI third.
Okay. All right, so Mr. Hunt, I know we've been going back and forth a bit here on some technical matters, but ultimately, what the plea agreement is that you're going to plead guilty to 1 count of operating while intoxicated as a third offense, and no contest to 1 count of resisting or obstructing a police officer. Is that the plea agreement that you've discussed with your attorney?
Yes, it is. I'm terribly sorry. I didn't mean to bother anybody. I don't remember the whole incident at all. I don't even remember leaving my son's house.
All right, so that's fine. That's why we'll take the no contest plea on the 1 charge, okay?
Right.
But you want to plead no contest to the RNO or resisting and obstructing, is that correct?
That's correct.
And then plead guilty to 1 count of operating while intoxicated third offense, is that correct?
Yes, sir, Your Honor.
And the prosecutor would drop all the other charges. Is that your understanding? And then the prosecutor would drop all the other charges. Is that your understanding?
I guess, yes.
Okay. Can you raise
I
your
don't
right hand?
recall.
All right. Do you need more time to talk to your lawyer about the plea agreement?
Right.
Yes, you want more time to talk to him?
No, I don't believe so.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Mr. Hun, are you currently on any probation or parole?
No. No,
Okay.
I wasn't, no.
All right.
guess I
And
was
you
on
understand that?
Probation, no. I was out on bond.
Okay. You understand that the maximum possible penalty you could face for operating while intoxicated third offense is up to 5 years and or a $5,000 fine. Do you understand that?
Yes, sir, I do.
And with that penalty in mind, what is your plea to that charge?
No contest.
Travis, do you want to have a chance to talk to Mr. Hahn here? I think we've got some misunderstandings.
I'm sorry, maybe I missed something, Your Honor. Were we, talking about the R&O charge, or were we talking about the?
No, I just told him the maximum penalty for the OWI third and asked him how he wants to plead, and he indicated no contest.
So, Mr. Hun, for the R&O, we wanted to plead no contest, correct? Because you don't remember that.
That's correct.
But for the drinking and driving that happened in December, you recall that, don't you?
Yes. Some,
Okay, so you were driving your car on December 4th, is that correct?
on December 5th. On when?
December 4th.
My truck, yes.
Okay. And the judge had asked you, how do you want to plead? He's asking about that first drinking and driving. So do you want to plead guilty to that charge?
Yes,
Okay. And you had been consuming alcohol on December 4th before driving, is that correct?
that's correct.
And you had consumed enough alcohol to be over the legal limit, is that correct?
That's correct.
And you may not remember this, but there was a blood draw with the result of a 0.179. Does that sound right?
That's right.
Blood alcohol? Okay. And you were in Kalkaska County when that occurred?
That's correct.
And prior to that, you had been convicted of drinking and driving. Is that also correct?
Correct.
And then one of those convictions was back in October of 2017 here in Kalkaska.
Yes,
Okay, and was another one of those convictions in March of 2020 here in Kalkaska?
yes, correct, yes.
Okay, and do you
That's all I'm
recall,
looking
and you pled to those
at. Did I what?
drinking, pled guilty to those drinking and drivings?
That's correct.
And you knew that you could have had a trial if you wanted to?
Do what?
You knew that you could have had a trial if you wanted to. You didn't have to plead guilty on those two
That's
previous
correct.
ones.
I could have, yes.
Okay, all right, thank you.
I suggested I have a trial.
No, it's just required that you knowingly pled. That's all. Just
I see.
that you knew your rights.
All right, Mr. Hun, I need to go through a few other things with you with regard to your rights, okay?
All right.
So you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, Your Honor, I do.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor. I'd like to ask mercy of the court.
Has anybody threatened you with anything to get you to plead guilty or no contest in this case?
Nobody offered me anything.
Has anybody promised you anything other than what we've talked about here today in court?
No, sir.
Is it your own free choice to enter these pleas?
Yes, sir.
Okay. So Mr. Ziegler, in terms of the factual basis for the OWI, are you satisfied with that?
I am.
Okay. In terms of the no contest plea, I have before me a report from.
This won't happen again.
Okay, just hold on a second, all right? Mr. Hun, I gotta talk to the lawyers about something for a minute, okay?
All right. I'm done drinking.
All right, good. I'm looking at Kalkaska Sheriff's Department report from Deputy Beaver. dated March 13th, 2025. The court is going to mark that as Court Exhibit 1. Have you reviewed that report, Mr. Ziegler?
I have.
And would you agree that that would provide a factual basis to support a finding that Mr. Hunt is guilty of resisting and obstructing?
I think Mr. Travis has just provided you the first page of that report, Your Honor, but I agree that the information contained therein is sufficient.
All right. And Mr. Travis, have you also looked at that exhibit?
I have, Your Honor.
Would you agree that it would provide a factual basis for a finding of guilt as to resisting or obstructing?
I do. I picked that particular page because it was pretty concise and seemed to cover everything.
Okay, I've reviewed it here and I agree. So the court's going to admit that as Court Exhibit 1. And Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis, are you?
I am not, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest guilty plea today?
I am.
Mr. Travis?
Yes, Your Honor.
All right, Mr. Hun, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied as to both charges that there are a factual basis to support a finding that you are guilty of each. The court will accept your pleas today. We'll set these matters for sentencing. Between now and the sentencing hearing, you'll be contacted by probation department for a pre-sentence report. And then you'll be transported here to Kalkaska to have that sentencing hearing here in person. Do you have any questions?
Not at this, no.
Okay, Mr. Hun, that's all for this hearing today. We're going to disconnect at this time.
All right, thank you.
Thank you. People versus Scott Way, case number 255002.
You're there, okay, just a moment to talk with Mr. Way.
Yes, let's take a short recess and we'll come back on the record.
He was posing as a 12-year-old. I initially, in going through the messages, did not see anything that referenced age. There was some text that referenced normally liking girls that are 18, but it didn't have an age. Mr. Ziegler then pointed out to me, and this is the kind of the tricky part, I don't know, and I think Mr. Ziegler will more fully argue it. At the end of, at least in the police report, the text string between Mr. Way and the alleged 12-year-old, who was a 40-plus-year-old man in Texas, there is a text where it says, where they're discussing their age. I'm 25. Oh, I'm 12's LOZs. But that appears to be, and I think Mr. Ziegler will say that's not the case, the last text in that conversation string. Because then I think starting after that is a text string, which I believe is between Mr. Way and someone who's talking about other things. I think the predator hunter gentleman, but I'm not real sure. So what I was trying to figure out was, did any reference to age preclude any of the negative or what could be inferred to be an accosting a minor, which is what Mr. Ziegler is going to argue later, is that Mr. Way was accosting a minor. And it's gotten even more muddy as we've talked about it personally. When I came here this morning, I didn't think it was there. Mr. Ziegler pointed it out to me that it is, but now what I don't know is necessarily where in the conversation the age revelation comes, and I'm kind of getting ahead of myself, but this is all important to Mr. Ziegler's argument that there is another felony, there is an accosting a minor, because accosting a minor requires either that they be a minor or that the defendant believe they are a minor. It's a one or the other. They don't actually have to be a minor. So it's somewhat important to that conversation whether the age portion of the alleged minor was raised or not, because then I would argue, Mr. Ziegler, the reason it wasn't charged is because it was a critical element was arguably failing in that charge. The argument that Mr. Way was aware or of a belief that this person who wasn't a child was a child, and that's all you have to establish to make that. So we're kind of spinning around at the moment on that, but that is my general objection is I previously, in going through everything this morning, would say that's Mr. Barrett's belief that Mr. Way knew he was talking to a 12-year-old. That's my objection.
Okay. We're going to pass this case for now. This is going to take a bit of time to hash this out, I think, and we're behind in the docket. I've got some hearings that are waiting on video. There's some others that aren't going to take quite as long, so I'd like to take some of these other cases. So let's pass this for the moment. Back to that. So, Mr. Way, if you can just be seated, we'll come back to your case. Sir, at the Wexford County Jail, can you tell me your name, please?
Eugene Hiddle.
Hiddle, okay. We'll go on the record in People versus Buck Hiddle. This is file number 234859 and 255049. The record should reflect Mr. Hiddle present today by video from Wexford County Jail. And if I can have counsel put your appearances on.
Ryan Ziegler on behalf of the
Kyle Travis on behalf of Mr. Hiddle, Your Honor.
Thank you. Mr. Travis, how did we want to proceed in these files today?
Your Honor, it's my understanding Mr. Hiddle would like to accept a plea offer. That plea offer would be pleading to a resisting and obstructing in both felony counts in front of Your Honor. I would dismiss all other counts and all other enhancements. It would also dismiss a number of misdemeanors that he's currently charged with, would preserve restitution for the 2 retail frauds, and would also dismiss a retail fraud that Mrs. Hiddle is a co-defendant on.
So 1 count in each file of resisting or obstructing, is that correct, Mr. Ziegler?
That's correct. Restitution to be preserved on any and all of the misdemeanor files that would be dismissed as part of the agreement.
Okay. Mr. Hiddle, were you able to hear all of that?
Yes, I was.
All right. And is that the agreement that you've discussed with your attorney?
Yes. Is there any way that I could have a few minutes to talk to him before I accepted it, or?
Yep. I'm going to put you on hold and then we can allow you to do that. Mr. Travis, if you want to, can you sign in? Okay. I can put the 2 of you into a breakout room and then move on to a different case while you're talking.
Thank you.
tired.
Mr. Seeger, were you ready on this Simpkins case?
I can be.
Okay, yeah, we can take that case. Simpkin, if you can come up to the front there. Just 1 second. Mr. Hiddle, the breakout room's open, but you might have to press something to enter into it there. All right, so we'll go on the record in People versus Taylor Simpkin. This is file number 255034. The record should reflect Ms. Simpkin's present here in the courtroom today. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of people.
Thomas Taylor Crane with on behalf of Ms. Simpkin.
This is the date and time set for sentencing in this matter. Ms. Simpkin, have you had an opportunity to go through that report with Mr. Seeger? Okay. Mr. Seeger, are there any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this score?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, you're right.
Any challenges to the scoring?
No, you're right.
Anything on behalf of the people for allocation?
Your Honor, this is the case where we had offered a plea with the understanding that the defendant was eligible for 7411. I think the defendant has had some slip ups on bond, but she is a good candidate for 7411. I think that, given her age, given her education, given her lack of any real criminal history, guidelines are 0 to 3. I think everything favors giving her an opportunity at 7411 probation. And if she's successful, all the better. And if she's unsuccessful, well, we're right back here to deal with the consequences of her failure. So to my eyes, Your Honor, 7411 is a win-win for the people. So I would ask the court, even though she has had some issues with drug screens on bond, to still give her the opportunity on 7411.
Thank you. Mr. Seeger.
Likewise, Your Honor, I would just ask the court to consider giving her an opportunity at 7411. Clearly, this is a situation that she needs to rectify. Clearly, this is a situation where we don't want her coming back. So to the extent that she's able to successfully complete probation, that would be helpful to her and everyone else. So I would just ask the court to impose that as it stands.
Thank you. Ms. Simpkin, anything you wanted to say today?
Just that I want to assure you that I am trying to move forward with my life and do better. I'm receiving counseling for my mental health and the substance abuse issues. And just something that I'm embarrassed about an issue before it's not going to happen again.
I did read through the report prior to the hearing today. I'm familiar with the circumstances of the charge here, as well as your background and your circumstances as well, based on the information in that report. And taking all of that into account, along with what you and the lawyers have had to say here today, I do think the recommendation is an appropriate way to move forward. And I'm going to follow that recommendation. I think it's absolutely appropriate to give you an opportunity, both through probation and through the 7411 statute, if you successfully plead it, to have this come off of your record. But I also think it's really, really important, based on what I read in the report, that you do follow through with any treatment, counseling, and prescribed medications that are recommended to you, because I think that's a really important key for you going forward. And I think this is a sign that this isn't something you can do just on your own. And so I hope that you take this as a sign that you need some help, at least for a while, with this. And if you do, I think moving forward, you can be successful. And all indications are that you could. So the court is going to sentence you to the probation as indicated for a period of 12 months pursuant to 7411. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report, which includes drug testing as directed by your agent, not using or possessing any controlled substances or paraphernalia unless they're prescribed to you, to only use your prescriptions as they're directed, and to avoid any police contacts. The court is going to sentence you to a period of 3 months. I'm going to hold that time in abeyance. So if you successfully complete your probation, you would never have to serve that time. However, if you violate your probation, you could be ordered to serve any or all of that time immediately. You do have credit for 2 days served. The court is going to impose a crime victim's assessment of $130, court costs of $325, attorney fees of $350, a $68 state cost, DNA testing fee of $60, and a supervision fee of $30 per month while you're on probation. Because this is pursuant to 7411, there are no written appellate rights. Mr. Barrett, does she need to check in with you today? Or? Yeah. Okay. So just talk to Agent Barrett before you leave the court today, and good luck to you going forward. Thank you.
Okay.
Can you see if Mr. Connolly is ready with his client?
Sorry, he's asked for a 5 minutes.
Mr. Horowitz, are you able to hear me okay?
I can. Good morning.
Okay, good morning. We're on the record now in People versus Michael English, file number 244923 and 244925. This was set for a final status conference today. We do have a trial set to begin in 2 weeks, I believe June 17th, on one of the files. I know the parties have filed a stipulation in order to adjourn that trial date, but I left this hearing on today because I have not signed that order yet. Mr. English is not present. He was writted. I did see the Department of Corrections facility where he's lodged in the waiting room. We're running a little bit behind on the docket. They've since disconnected. I don't know if that's something that Department of Corrections did or Mr. English did. Mr. English has in the past voluntarily terminated his participation in the hearings before the court. So, but it's impossible for me to determine that. Nevertheless, I would like to discuss the adjournment. And I just want to make a clear record of it, primarily because Mr. English, Mr. Horowitz, as you're aware through you, has recently filed a motion regarding time limits in the case, which the court denied, but which make me hesitant to further adjourn any trial dates, even if they're at defense counsel's request, given Mr. English's difficulties with counsel. So I guess, Mr. Horowitz, I'd like you to make a record. I think the adjournment and the stipulation was arrived at your request. Is that right?
That's correct, Your Honor. I'm actually out of town right now. I'm beginning a murder trial out of town this Thursday. It's been a long time coming, and I expect that it will last for 2 or 3 weeks.
All right. Can you tell me the jurisdiction where that trial is at?
I'm in Fairbanks, Alaska.
Oh, okay. All right. I didn't realize. So you're licensed to practice in Alaska as well?
As well as New York.
Okay. All right. And Mr. Ziegler, you obviously don't have an objection. You stipulated to the adjournment.
That's correct, Your Honor. And after discussing this with Mr. Horowitz, I'm aware that he was going to be in trial for these dates. I don't have any objection to the adjournment being requested.
All right, so I guess what I had planned to address on the record today, Mr. Horowitz, was I was going to indicate that I was going to communicate with the trial judge. I was assuming that it was a Michigan case, maybe even, obviously not 46th Circuit, but a local Northern Michigan case. My intention was to communicate with the judge in your case and inform him of the status of this file or her to see if they would be willing to adjourn their trial so that our trial could go forward. Obviously, that's not going to happen. And that's not a practical solution given that you're already in Alaska. So for those reasons, the court will sign the stipulation and will reset Mr. English's trial. It's a one-day trial, so I anticipate the court can get a relatively quick date for that. And we'll proceed further as scheduled. Mr. Horowitz, anything else that I can address for yourself today?
No, Judge, but I appreciate you making the record. Thank you.
Ziegler?
Nothing further, Your Honor.
Okay. All right. Thank you. Mr. Horowitz, you're free to disconnect at this time.
Thank you.
Back in. Mr. Hiddle, are you able to hear me?
Yes, I am.
All right. Did you have, oh, I'm sorry. We'll take Mr. Connolly's case. Mr. Hiddle, we're going to take another case, but we're just going to keep you on the line here. All right.
Yes, sir.
All right, we'll call People versus Anthony Joe Lambert, file number 255020. The record should reflect Mr. Lambert's present here in the courtroom today, along with his counsel, Mr. Connolly. We have Ziegler here on behalf of the people. This is the date and time set for sentencing hearing. Mr. Lambert, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Connolly about that?
Yes, sir.
Mr. Connolly, are there any additions, deletions, or corrections to that?
Your Honor, just two additions, if I may. I've shown them to Mr. Ziegler. There's an ATS, a letter for addiction treatment services, indicating that my client's been approved for inpatient residential treatment. He also had an assessment done through Catholic Human Services while he was in the Wexford County Jail. There's a recommendation attached to that, if Your Honor would care to briefly view these documents.
Okay, sure. If you want to handle it. Mr. Connolly, did you want these attached to the PSI?
No, Your Honor, just for your review.
Thank you. Are there any other additions, deletions, or corrections?
None, Your Honor. Thank you.
Any challenges to this morning?
No, Your Honor. Thank you.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, Mr. Lambert's before you today for his 33rd conviction. Suffice to say, his record is atrocious. He has 122 PRV points in this case. And the grid tops out at 75 PRV points. He was also on parole for possession of meth, same offense he's being convicted of and sentenced for here today. He also admitted during the process of this case to law enforcement that he was going to deliver the meth in this case to someone else in Mansalona. Without belaboring Mr. Lambert's history, he's simply not a good candidate for community supervision in this case, Your Honor. He's well deserving of a prison commitment. The defendant was very forthcoming with law enforcement, which in my view is in his favor in this case. However, his record and his parole status militate against a lower sentence. I think the court would be perfectly justified in giving him the top end of the guidelines in this case, just based on his record and his parole status alone. However, given that he was relatively cooperative with law enforcement, I think a sentence of 18 months is fair, given his cooperation. So I would ask for that, Your Honor, 18 months consecutive to any parole violations.
Thank you, Mr. Connolly.
Thank you, Your Honor. And obviously, Your Honor, he does not get any credit for the time he sat, but there's a figure there. I believe it's at 122 days, Your Honor. I believe he sat. So I would ask that you take that into consideration. I know he's not due credit, but if you consider that in any sentence you might give. So this is the first time that I've met Mr. Lambert and interacted with him. He was with me straightforward and explained what happened and admitted responsibility for his actions right off the bat. So I was a little concerned when I saw his criminal history that he might be sort of somebody who was going to be difficult to deal with and not readily admit his conduct, but he did. He acknowledged that he knew better than to do what he did, that he shouldn't have been around the people he was around. We had some discussions, in fact, about his wife. He and his wife had quite the argument before him hanging out with these folks, saying, you know what's going to happen. You know what's going to happen if you're around them, and it did happen. So, and he acknowledged to me that by now he has to know better. He has to know better than to engage in this behavior. He has to know better than to be around people who are engaging in this type of behavior. Again, lengthy record, as Mr. Ziga pointed out. He spent a lot of time incarcerated over his life. He's almost the same age as I am, and I can't imagine spending that much time in jail and prison. So he knows what he can and cannot do and who he can and cannot be around. And I think he's gotten to the point now where he just has to make that choice. Like he explained to me in detail, he's like the things he's missed, the family things he's missed, why he engages in this behavior, sort of like, I don't know how it's akin to almost like being in school and having like what one of your peers say, oh, you should do this. And he just doesn't seem to have the ability to say no. He goes along with these things when he knows it's wrong and he knows that there's going to be repercussions. So essentially, until he gets it into his mind that he's no longer going to be around these folks or to engage in this behavior, he understands what the repercussions for his actions are. So he has written a statement to Your Honor. I explained to him if he's going to read a statement to read it slowly and clearly so that he's not racing through it. But he is desirous, I should say, Your Honor, of remaining local if possible. He's on parole. I understand that complicates things even worse because it's a consecutive sentence. He's saying all the right things to me, Your Honor, and now it's time for him to start doing the right things. But that said, Your Honor, he understands there's a price to be paid for the conduct he engaged in.
All right, thank you. Mr. Lambert, anything you wanted to say?
Yes, sir. First off, I want to be very, very candid with the whole entire scenario without sounding like I'm taking anything away from the things. Like when it was said that I was delivering something to Mansalone or whatever, when the police were arresting me or finding the stuff on me, I just did that. Oh, that's not mine. I was given it in payment for something that I did. I wasn't delivering it to anybody. I didn't know what I was going to do with it. I just received it. I didn't have a plan to deliver it to anybody. I probably would have at some point in time. So I'm not trying to say I'm not guilty of that, but I wasn't trafficking it as a planned thing to some person in Mansalona or anything like that. I just was trying to be like, it's not mine. I'm not in trouble. I didn't do that. Now it comes out like I was trafficking drugs as something, but I want to point that out that I wasn't doing that. I was just had drugs on me because somebody gave them to me for work that I did. Yes, I'm sorry. Your Honor, I feel so bad standing here in these circumstances. I feel like a big failure. I have let a lot of the people rooting for me down. My heart breaks as I constantly think about all of them. My wife, my children, my family, my parole officer, previous people I worked for and with, the Michigan Works people that helped me get funding to advance my career opportunities, the instructors of my trucking school, and my peers of all walks of life, everyone really. I'm very determined to be a success story. I don't want to waste the hopes and resources I have that have been invested into me. I feel sick fearing my actions have failed everyone. My actions have caused all hopes and well wishes and resources to be wasted so far. I have worked really hard, gaining skills and abilities and certifications into my overall personal toolbox. I've also received a good amount of investment from others. I put a lot in jeopardy. A lot of hard work and investment I've accumulated over the last few years. Without your mercy, I have squandered most of that. It also seems like the easy answer to dealing with me when I cross the line is to lock me up. Not much is thought of the positive moments of my past. And a lot is focused on the worst moments, which makes sense being that I'm being judged over negative ones. They must not see much hope much hope for me and typically give me a sentence on the heavy side. The argument being, let's save the rest of us from having to deal with him for as long as possible. On paper, in this setting, I look like a bad guy. And sometimes I don't seem to be able to avoid being in trouble. Believe it or not, I have done a lot of work in counseling, understanding my issues with criminal thinking and curbing it. I really don't want to be a bad guy. My intentions right now was to be driving a truck, weighing everything. It seemed like the perfect situation for me. I worked really hard to achieve that. I won't bore you with all the steps involved. Trust that it was quite extensive. And it felt, I felt proud. I was happy staying clean. All I had left to do was the behind the wheel and walk around exam for the Secretary of State. I had to wait a while to schedule that exam and got complacent with my overall life mission. My learner's permit is valid until October. I already have that exam paid for, but after October, all the efforts and resources have been squandered. All those efforts and resources have been squandered. I was looking forward to being a success, helpful to everybody rather than a drain. In the blink of an eye, my proclivity for criminal thinking has jeopardized all of that and a lot more. I feel so much shame over that. I really messed up. If you could please show me some mercy here, I will not take it for granted. I will try really hard to not squander everything. And I really do want to do and be good. Although I look bad on paper in this setting, I do honestly feel like I have a lot of redeeming qualities. I take pride in my work ethic. I'm a knowledgeable and capable person, and I care about other people. I constantly focus on being a helpful person. My issues with criminal thinking and behavior are unique as in anyone's, I guess. I do not feel that me being locked up a lot is helpful to me or anyone. I have sought out counseling for my unique circumstances. I believe further incarceration can further compound my problems and issues. I hope there is a way we can all work together on a success story. I'm currently doing counseling with Amy Cox through Catholic Human Services. Years ago, she worked with me and I sought out her help now. I feel like we have made some great gains in recognition of the true recognition of my issues. I tracked down the funding for this counseling through my insurance, and I also have funding for an inpatient stay through ATS. I offer an in-depth look at my counseling. I would feel good for me to sign a waiver for others to be able to see the details of my issues and my counseling in hopes that that knowledge could be helpful to others. I really do want to be and do good. I want the courts to see that and feel good about the path that I'm on. I know the chances of me not getting a prison term here are not in my favor. I know that the easy thing to do is say he crossed the line and these are the consequences. But if there was ever a time when someone was going to try to make something out of any mercy you're willing to show him, this is that time. It's not just something I'm saying. I really do want to do and be good. I honestly mean that. I had some.
Some of it's becoming repetitious, Your Honor. I'm just trying to continue to read through the whole thing, however.
Well, this is your time, Mr.
All
right. I can say whatever you want me to know.
Oh, okay. I don't want to waste your guys' time, but
this is your time. This is an important hearing for you, and you have the right to speak.
I was trying hard. I got caught up in circumstances that in hindsight, I'm baffled I was so dumb to be involved in. In the moment, with my issues, somehow my criminal thinking did some sort of mental gymnastics to constitute being paid drugs as payment for work I rendered was acceptable. At first, I declined, but there was no money. At least it was something. I don't have the literary skill to describe how dumb I feel now. I know what's right and wrong, but somehow can still make criminal moves when I have no intentions on being that guy. My wife and I even fought about whether I should go over there or not because we were aware of the criminal element. I understand, I ultimately overruled her concerns needing the money, and I was supposed to make putting furniture together, telling her I don't have to worry about anything because I'm not doing anything wrong. Then for some reason there was no money, but offered a greater value if I accepted payment in drugs. She was so right, and I have failed in ways that genuinely sickens me. When I think deep about it, I'm so disappointed in myself that it's crushing. It's hard to explain and understand like this. That is why I offer the details of my counseling efforts. I understand that life will always challenge me with these sorts of situations, and I need to be a better developed person. I like to view myself as a valuable and helpful person to have around. I don't want to be a drain or hurtful to society and the people I love, and the people that I love and the people that love me could really use my help rather than having to help me. I really want to live a life where I'm proud of myself and people are proud to know me instead of ashamed. I have just a little bit more. I don't want you to feel like wait, is it okay?
Again, this is your time. I want to hear whatever it is that you want.
Being housed in Wexford County, I've seen Wexford County do a program where they do a bond and defer sentencing until after treatment or some proving tribulation. Good performance possibly earning favorable consideration, and poor performance possibly earning doom. When they reconvene the sentencing after the events transpire. I understand there is no program like that set up here, and my parole circumstances make things tricky to deal with through a probation standpoint. But please, if there is any way we can think outside of the box and be creative about this, please help me. Please see I'm not a lost cause. I made the most out of the last prison sentence you gave me. I achieved a lot while I was there. I probably set the record for achievements while I was at Vocational Village. I messed up. I made unfathomable mistakes. I'm very sorry I messed up so bad. I truly mean that. I feel so bad. I have been a horrible husband, father, son, brother, friend, person. My community has suffered over my actions. I feel so bad. It really hurts right now. I don't even know how to describe the shame I feel. I'm very humble. I'm going to be a success story. My prison isn't going to be helpful to me or the people around me right now. Please help me. I really do want to be a person people are proud of. Perhaps we can figure out some sort of jail sentence where I can work and have the opportunity to prove myself and not waste all the work and resources already invested. I also can continue the productive counseling I've been working on. Please give me some chance and I will try so hard to make good and act like a smarter person. There has to be something else we can try besides more prison, something productive. I really wish to be a productive member of society. Please see the good person I want to be and help with a positive alternative. I'm going to act smarter no matter what. There has to be a better way. I know I'm wrong. This failure is surprising to me. This has been incredibly humbling. Thank you for hearing me out. Sincerely, Anthony Lambert.
All right, thank you.
Sorry about the length of that.
Well, there's nothing to apologize for, and that's information that's important for me to know. I think a lot of times it's important for you to say some of those things in public out loud.
My family's here too, so they get to hear me say that.
Right. So that's why I don't want to cut you short, because there are things that you need to say and should say, and not just for my benefit, but for your own benefit and the benefit of your family, as you said. So there's no reason to apologize. And I listened to everything that you had to say.
Thank you.
I read through the report, of course. I'm familiar with the circumstances here, I'm familiar with your background and your circumstances. We all know what's gone on before. Prosecutor pointed it out. You've had 16 prior jail sentences, you've had 3 prior prison sentences. You've been on probation 7 times. And so, you know, all of that, it does play a role in the court's consideration. And I think you're completely sincere. You appear to be very sincere to me in your statement. A lot of the things you said don't sound like the things that people say just as a way to get sympathy. And I think, you know, everybody gets to a point in their life where they're sick of doing what they've been doing when it hasn't brought them good results. And I think at your age, you're getting to that point where you just don't want to do this anymore. And a lot of times that's what it takes for people to make a change. And it concerns me when people talk about the court or the system thinking that there's no hope for rehabilitation, because I don't think that's not the way I look at it as a judge. I think people can be rehabilitated at any time in their life, particularly when the problem deals with drugs. You know, people have very long journeys to recovery sometimes, and they involve lots of twists and turns that are not good. But I don't think anybody's ever passed rehabilitation. The question for me as a judge is whether or not to continue to commit community resources towards that rehabilitation, or whether as the court we say, all right, you know, he's been on probation 7 times, parole however many times, continuing to reoffend. At some point, we're just not going to put community resources towards your rehabilitation. But that doesn't mean you can't be rehabilitated, and that doesn't mean that you can't do it for yourself without the court ordering it. As you've indicated, you've investigated that, you know, through insurance, through other things, there's ways to get help on your own outside of the order of a court. And so I think you can move on from this. I think you have the capacity to do that. I think based on what you said, you have the desire to do that. And I think what remains to be seen is what you do to get to that point. But at this point, from the court standpoint, I would not be justified in continuing to give you opportunities through local penalties and probation, because it hasn't been successful. You know, in this case, you were on parole. I mean, if there's ever a time to be following everything to a T and not do the kind of things that you were doing, being on parole is that time. And here we are, and I don't have anything to go on to say, if I put you on probation here, that it's going to be any different.
I was doing a lot of good while it was up.
And I'm saying you weren't, but what I'm saying is this still happened while you were on parole. And so from that standpoint, it just, there's no justification for the court to put you on probation here or a local sentence. So I think an appropriate penalty for the reasons I've stated is a Department of Corrections sanction. I think there is room for mitigation for the reasons indicated by Mr. Ziegler. I think an 18-month sentence is appropriate. It accounts for your conduct in this case. It's justified by your past history and your parole status at the time that this occurred. The court is going to sentence you to 18 months to 10 years in the Michigan Department of Corrections. You have credit for 0 time served based on your parole status. The court is going to order that sentence be served as required by statute, consecutive to parole. A crime victim's assessment of $130, court costs of $350, and a $68 state cost. You do have the ability to seek an appeal of the sentence, and Mr. Connolly, have the appellate rights there. You can have.
Yes, right. So you want to appeal your sentence, you have 6 months from today's date, okay? You'd have to turn this form in either to the Department of Corrections, jail, 6 months in. Today's date. Your Honor, do you want him to, just one copy for the court's records and the rest from Mr. Lambert, or how do you?
Yes, the highlighted one.
Highlighted ones, yours, Scott. All right, thank you, Your Honor. Mr. Lambert has initialed and dated his notice of appellate's rights form. I've advised him he has 6 months' time in which to act if he wishes to appeal. And I have the original copy for your honor's clerk.
Thank you. Good luck to you going forward. Mr. Travis, are you ready to proceed with Mr. Hill's files?
I believe so, Your Honor. I have a piece of information to give Mr. Hiddle that I was able to talk to Mr. Ziegler about.
Okay.
Well, I talked to Mr. Ziegler. He had indicated that if the cases are resolved, he would dismiss both those misdemeanors today, so long as restitution is preserved.
So then no contact to be lifted.
Once they're dismissed, there is no contact.
So that would end today.
Probably tomorrow, because he's got to dismiss them and they've got to get signed. But yes, he would dismiss those cases.
Okay, we'll go ahead and plead then.
Okay.
All right, so just for the record, the charges are the same, correct, that he's pleading to?
That's correct, Your Honor. The only difference is the timing of the nollies on certain cases.
Okay.
There's a number of misdemeanors that were going to be dismissed as part of this. There's a no contact in place between Mr. Hiddle and his wife, and if they didn't get dismissed soon, that would just continue.
Sure, okay. So, Mr. Hiddle, is it your desire to go forward with this plea agreement as we've previously stated?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Mr. Hiddle, are you currently on any kind of probation or parole?
No.
You understand that you're pleading guilty to 2 counts of resisting or obstructing a police officer. Those carry with them each a maximum possible penalty of up to 2 years and or a $2,000 fine. Do you understand that?
Yes, sir.
With that maximum possible penalty in mind, what is your plea to each of those charges today?
I plead guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making today. The only way you can appeal it is by leave, and that means that you have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've discussed here on the record today?
No, just that the files with the no contact to be lifted for I can have contact with.
Okay. Is it your own free choice to enter these pleas?
Yes.
Are you pleading guilty because you are actually guilty of each of these charges?
Yeah.
All right, so I'm going to talk about the older case. This is the one that goes all the way back to 2020, April 22nd of 2020. Do you recall the interaction with police on that day?
Yes, I do.
All right, did that interaction occur here in Kalkaska County?
Yes, sir.
Did that involve Sergeant Paul Bellinger of the Kalkaska County Sheriff's Department?
Yes.
And when you encountered Sergeant Bellinger that day, were you aware that he was a police officer?
No, I was not. It was dark and I had problems with my sister's boyfriend, and that's actually about orders that he identified his stuff after he ran.
Was he wearing a uniform?
Yes, but it was pure dark.
All right, so you couldn't see that he was a police officer at the time that you were interacting with him?
No, I could not. Not until I already done ran and he said police.
All right, so after the time that you knew he was a police officer, what did you do to resist or obstruct him in his duties?
I hid out of fear.
I couldn't understand.
He hid out of fear.
Okay, all right, so you knew that Sergeant Bellinger was there to perform his duties as a police officer by that time, and you did not comply with his commands and you hid from him, is that correct?
Yes, sir.
Okay. As to that charge, Mr. Ziegler, are you satisfied with the factual basis?
I'm satisfied.
Okay. So, Mr. Hiddle, the second incident that I'd like to discuss is more recent. That's from March 28th of this year, 2025. Do you recall that incident?
Yes, sir.
And on that date, did you also come into contact with a deputy from Kalkaska County?
Yes.
Did you know that that deputy was there to perform his duties as a police officer?
Yes, sir, I did.
And what did you do to resist or obstruct him in his duties at that time?
I ran and hid.
Okay. And did that occur here in Kalkaska County?
Yes.
All right, as to that charge, Mr. Ziegler?
I'm satisfied.
Mr. Travis?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
Nothing other than what's been placed on the record.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, Your Honor.
Mr. Hiddle, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these counts. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. Between now and then, somebody from the probation department will be in touch with you to prepare a pre-sentence report. And you'll have an opportunity to go through that with your attorney before the sentencing hearing. Mr. Travis, anything further today?
I don't believe so. Mr. Hiddle, anything further?
Just what we talked about on the meeting, if you want to bring that up, that's fine.
I couldn't hear that, Mr. Hiddle.
Just if you want to bring up what we talked about on the meeting, but if not, it's fine. That's all.
Okay, we'll leave it as it is.
Okay. Thank you, Mr. Hiddle. That's all for today, and the court is going to disconnect at this time.
Thank you.
Ms. Leach, do we have our defendant ready in your case? What's his name?
Mr. Fox.
What is it?
Is it Fox?
Fox. Is that what it is? Yeah.
Mr. Fox.
Perfect case number.
Okay, good. This is a 1, 2, 0, 4 pass. Mr. Fox, I'm gonna have you go right to that podium right there. Yes. We're on the record in, who's the plaintiff in this case?
Melissa Hurd, I brought the people.
Okay, great. Get a photo of that, please. Your name is Darren Fox?
Yes, sir.
Okay, so this is Melissa Hurd versus Darren Fox, file number 1211044. Conducting this hearing on behalf of Judge Boudet. Mr. Fox is present here in the courtroom today. Mr. Fox, you're before the court today because you were arrested on a warrant for a failure to pay child support. Do you understand why you're before the court today?
Yes, sir.
Okay. We have Ms. Leach present on behalf of the front of the court. Ms. Leach, can you tell me what the front of the court is asking the court to do here today in this case?
To give you a little bit of background, Mr. Fox has a monthly obligation of $482 plus $100 ordered on arrears for a total of $582 per month. His arrears on this case are $7,180.44. We had received an involuntary payment in May of $500.
$50 in March and $200 in February. We've had multiple show causes from the referee on this case. Just going kind of back to January, at that hearing on January 10th, he had stated that he was ordered.
Well, that's it. That's going to be it for today. We'll pick this back up again another time. I want to thank everybody who is a subscriber to this channel, and your support means a lot to me. It looks like we're going to be losing Judge Boyd. Judge Boyd lost the election, and at the end of this year, her term would be ending. So I wish Judge Boyd a long, happy life. As long as she's putting out content, I'm going to have content from her. That's going to be sad. But that's it for today, ladies and gentlemen. You all have a wonderful evening, and I will see you guys tomorrow. Ciao, ciao, and ta-ta.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in hand, making magic flow. Every broken part, you help me grow. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's right. When I'm falling apart, you put me back together. Daniel, you make it better. From the wires tangled up to the broken dreams, you know how to man all my scattered seams. With your steady hands, you refill my heart. Every piece that's lost gets a brand new start. You fix it all, you fix it all. Daniel, you make it right. Daniel, everything's bright. When I'm falling apart, you put me back together. Daniel, you make it better. Fix it, Daniel, make it right. When the world shuts down, and I can't see clear, you're my solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. Fix it all, I will standing tall to all you do. From the highest peak, I can see it through. With your care and touch, everything's okay. Daniel, you're